state is proceeding on the lesser included offense of driving while intoxicated first as a Class B misdemeanor to range upon.
From the start, the stakes are clear. A Class B misdemeanor in Texas might not sound dramatic, but 180 days in jail is 6 months of your life. And notice this, the state is already proceeding on a lesser included offense. That usually signals a plea deal is in motion. The real question is, how much more serious were the original charges?
180 days in the Bexar County Jail and up to a $2,000 22 CR 10960, State of Texas versus Norma Vasquez Ledesma. Can I have parties announced for the record for the state?
Jason Jorgens for the state.
Defense?
Charles Sierra for this prosecution.
And are you Ms. Vasquez Ledesma? Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Ms. Ledesma, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it? Did you sign it? Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We're not amending the indictment, Your Honor, but we do have an agreement to plead to the lesser included offense of driving while intoxicated first.
All right. Ms. Ledesma, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand the state is proceeding on the lesser included offense of driving while intoxicated first as a Class B misdemeanor? The range of punishment is up to 180 days in the Bexar County Jail and up to a $2,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
This is the moment that really matters. She's giving up her constitutional rights. No jury trial, no cross-examination, no forcing the state to prove its case. In exchange, she gets certainty. That's the psychology of plea bargaining. So what would you do? Take your chances at trial, or accept the deal right in front of you?
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent? Did you understand by entering this plea bargain agreement you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Ledesma, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than a plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea, the state is proceeding on the lesser included offense of driving while intoxicated as a first offense. Punishment.
On paper, this sounds manageable. Probation instead of jail time. But probation isn't freedom. It's supervision. Every condition is a rule, and every violation is a fast track straight back to those 180 days behind bars.
That's at 180 days in the Bexar County Jail. There's a $2,000 fine. No application for deferred adjudication. State recommends community supervision, and there's to be restitution for laboratory testing. Did you understand that to be the plea?
Yes,
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
Excuse me, Your Honor.
Have there been any such motions?
Yes, Your Honor.
No, have there been any motions
Any motions?
that have been filed,
No.
heard, and ruled upon by the court? You need to say yes or no so the court reporter can hear.
Said no.
All right.
I
Next
misunderstood you. I apologize.
No problem. Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 2 years. There be a TAP evaluation, 72 hours in the Bexar County Jail, 100 hours of community service restitution, DWI education, DWI victim impact panel, ignition interlock for half the term, 2 years driver's license suspension, parenting course, scram ankle monitor for 60 days, and regular UAs. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offense of DWI first, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Yes, Your Honor. The state offers Exhibit 1, the defendant's waivers and stipulation of evidence.
Any objections?
No objection.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and considered the stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are we proceeding with sentencing? Anything you wish to say on behalf of your client?
With respect to the recommendations by the VA with the 2-year license suspension, my client cleans houses for a living. He needs to be able to drive as does to take children to school, children in school activities and so forth. So I'm asking the court for some leniency on
The judge has read the police report, and clearly something in there struck a nerve. This isn't just paperwork anymore. This is about children in the car, and driving the wrong way into traffic. That's when courtroom formality shifts into moral accountability.
No, her license is going to be suspended. Did you read this police report?
Yeah, I don't.
Oh, do you want a jury trial? Because let me just tell you what I read in this police report.
I know.
Now, let me tell you what it is, because I don't think you have internalized what's in this police report. So you had your children with you. And according to this, you were pulled over because you were driving against traffic. So that means that you were driving improperly. You were going against traffic, which means other people could have been injured. In the vehicle, you had an 8-year-old and a 10-year-old. And it says, when I arrived on location, AP, that's you, was standing on the sidewalk, unhandcuffed. I had her walk to the front of my patrol car. She said she did not know why she was stopped, but supposedly she was going against traffic. AP then admitted to consuming 2 drinks at Ingram Park Mall at a bar, but did not know the name of the bar. She started drinking at 8 p.m. and stopped at 9 p.m. AP later denied consuming any alcohol and also denied that she first admitted to consuming alcohol. She did not know what time it was. She said she was not driving. She was shopping. Last date at 3 p.m. And it's not under a doctor's care and has no prescribed medications. During the interview, she said she needed to use the bathroom. So I advised her that I would have a female officer to make the location, and she walked away to a tree and started to urinate. After she finished urinating, I completed the interview. She had bloodshot, glassy eyes, slurred speech, and was unsteady on her feet. The odor of alcohol was also getting stronger as she kept talking. They did the HGN. You failed the HGN. So I am not sympathetic to her with the driver's license suspension. Her license is going to be suspended.
This isn't just a legal issue, it's a human one. Judges usually remain measured, but when children are involved, emotions run higher. This is the moment the courtroom stops being procedural and becomes personal. And for everyone watching, can you imagine sitting in that defendant's seat right now?